and just give the members a minute to read through the amendment that was drafted for us by the Department of Education. I know Representative Paquette had already had a chance to look through. Would you like to ask any questions of the folks who are here to share their wisdom with us?
Yes, thank you. The only thing that I had questions about is there's somewhere where it said that they're fingerprints. And then where am I can't find it again, of course.
It was paragraph 3, section A, I think, right?
Yes. In the event of the first set of fingerprints is invalid due to insufficient pattern, a second set of fingerprints shall be taken in order to complete the criminal history check if after 2 attempts, a set of fingerprints is invalid due to insufficient pattern, the department may, in lieu of the criminal history records check, accept police clearance from every city, town, county where they've lived during the past 10 years. Is this part new? Like new completely?
Good morning. Steve Appleby, Auburn, New Hampshire, Department of Education Division Director. Thank you for that question. That is actually in the current statute. All we've done, though, is extended from 5 years to 10 years, the history.
So is the new, so that, I'm just trying to get clear on what is already in law and what this changes. Is it kind of like paragraph B down is new?
I have a copy of the current.
Okay.
Would that help? I've also brought a list of offenses that we screened for. I don't know if that would be helpful to the committee as well. Yeah, okay.
Just another quick question. So the list of offenses, is that the same as was before, or there have been any added?
Thank you for the question. Currently, as you look at that list, there are some that are in bold.
Oh, yes.
Those represent HB 1373 in the current session, but otherwise, all of the other offenses are current offenses that we screen for.
Okay, thank you.
And I would add, if I could,
Sure.
this amendment essentially takes, we have a current process where we conduct a criminal history record check for bus drivers statewide, so they don't have to go get checked everywhere. This model essentially adds on to that process by including the providers such as OTs, PTs, speech paths, who really do kind of the same thing where they go to different districts.
Yes.
So it's the same process, just an expanded group of individuals.
I remember when we had spoken before, you had mentioned like having to resubmit this to the FBI if it was drafted a certain way? I just wanted to make sure that this is drafted in a way that won't make it so you'll have to do that. Sorry.
Hi, my name is Christine Shea. I'm the administrator of the Criminal Records Unit for the State Police. And yes, anytime we change legislation that already has fingerprinting in it that's already been authorized by the FBI, we have to resubmit that for their approval.
Okay, so you'll have to resubmit, like including the school bus driver stuff, or
Correct. It'll be the entire statute will be resubmitted.
and that's okay with the.
It happens all the time with states because, even where we're talking about the list of offenses, that has to get resubmitted because it's a change to a statute that already has been approved.
All right, thank you. That makes sense.
It's all good.
So this is consistent with what you've been doing for bus drivers and
That is correct.
yeah.
Yeah, from our standpoint, it would be the same process. It's just another group of applicants that would be included in that.
makes sense. Thank you.
All right, thank you so much for both coming out here. I think we're good. I'll close the subcommittee meeting.
Thank you.
Morning. Would you please rise and join me for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. With that, I open the public hearing, or continue public hearing on House Bill 1408. And do we have anyone to speak to us on this? We do.
Pink card? I knew.
It's our very own alley.
I would ask the chair to punish her for failure to put in a pink card.
I think that may be in order.
I think being clerk is punishment enough.
You have that entirely right. You may
Particularly given the
proceed.
Chair, right?
Pardon me as I pull up the language for this bill. For the record, my name is Representative Alessandra Murray. I represent Hillsborough District 20, which is Manchester Ward 9. And I'm here to introduce HB 1084. Nope, what is it? 1408, dyslexia. So this bill I introduced at the request of a constituent. He came to the original hearing, but unfortunately wasn't able to be here today. But specifically, this bill creates a misdemeanor offense for any elected officials who publicly disclose or dox constituents with the intent to harm or harass that constituent. I know we have other legislation that makes doxing entirely a crime in and of itself. So if that passes, maybe this one isn't necessary on its own. But my intention with this was to ensure that elected officials are never interfering with their constituents feeling safe and able to share their opinion in public. So this happened to a constituent of mine where he had posted something online on Facebook. Someone who was elected in the city then took that post and posted online where he worked, his name, his address, and everything in an attempt to get him fired, which he did get fired. I had another friend of mine also who had a similar thing happen, but in a less public way, which feels harder to address, but where he shared something in a testimony, elected official did not like what he said, got him fired. So this is expressly to address those issues and make sure that our constituents never feel like the people that, you know, are supposed to be representing them can then go and like use their words against them. Yeah, that's about it.
Thank you. Did any of those officials that you're talking about access information that any member of the public wouldn't have been able to? Did they use their position to somehow get things to use against that person?
In the case, the second case, yes. In the first case, no.
All right, thank you. That's concerning. Yeah. Representative Prue.
So, not knowing what the testimony was and what have you, were they trying to defend themselves? Or were they, yeah, no. Because I look at, you know, the ability for freedom of speech, right? And why should we inhibit an elected official to come to their own defense, I guess, is what popped into my head.
Yeah.
But I don't know what the case was, so that's
Yeah.
why I asked that question.
I'll share some details, but I just don't want to make a ton of, accusations on the record. But so in the first case, it was completely unrelated to the elected official. Just a member of the public shared their opinion, and then that elected official took that and posted it with the person's workplace in an attempt to get them fired. In the second position or case, someone was criticizing the local police department, and then someone from the police department was able to go and then get them fired for what they said during public testimony in a city council meeting.
Follow up? So it was public testimony? Mm-hmm. So it was out there already?
In the public testimony, the person shared their opinion on the local law enforcement department, and then the police, someone from that department later went and got this person fired for what they said during
So
public
this wouldn't
testimony.
cover that. Anyway.
Mine's good. Here, use mine. Thank you, Mr. Chairman. You, Representative, I just want to clarify. So when you're saying that, they took this information and then they went and had the person fired, that isn't actually who was responsible for the firing, though, right? There's obviously a supervisor that actually did it. So it wasn't the person that got them fired. It was the person did something that, and the result was them being fired. Thank you.
Yeah, it's hard. I just don't want to get into too many details because I don't want to but the person leveraged the fact that they were in law enforcement to get this person fired. But again, that case is less applicable because it was less of a public doxing thing and more of a behind the scenes. But the first case was where a person posted something, their elected official took that post, shared it alongside their workplace information, and then that person got fired.
I think we got it. Representative Lascelles, you have a question?
Yes, thank you. Thank you for taking my question. So in the second case, do you feel it was the elected official using their power as an elected official to put undue influence on the workplace that then resulted in them getting fired?
Yes.
Thank you.
Seeing no further questions, thank you for your
Thank you.
testimony. Is there anyone else who wants to testify on this bill? Please come forward. Kathy? Okay.
Registry of Deeds Association. Thanks. Good morning, members of the Criminal Justice and Public Safety Committee. I'm here representing, as I said, the Registry of Deeds Association. Although it is admirable that the bill as proposed seems to be, the goal is to prevent harassment and against individuals. Our concern as the Registers of Deeds is the way that it's written, that it may undermine our duties as the Registers of Deeds. Every day we have to record documents that necessarily require by statute personal identifying information. And we're asking that if this bill were to pass, that there be an exemption for the Registers of Deeds and the staff of the registry. If this bill goes into effect, I think what most of our concern is regarding the section of the bill, section 4A, which allows a constituent to file a request that their information be removed as long as they state that they are concerned about their safety or the safety of their immediate family members. There's all kinds of concerns about that. I mean, I think that's what triggers our biggest concern, because individuals, could come forward, state that, feel subjectively, that they are, in fear of their safety. And we could have many individuals then with documents that are not open to the public. And that's going to be a real concern for the property records and the real estate industry. So that's our concern. So we just are asking that there at least be an exemption.
Thank you. With regard to the part of, as far as breaking the law, the bill requires intent to harm. So that would alleviate anything you're doing in your official capacity, correct?
It does, but this section 4, it's not, section 4 shows that, I guess our concern is that we're trying to avoid, any kind of concerns regarding that.
Okay, so in other words, anything that's already lawful and necessary to
Yes.
publicly disclose shouldn't be suppressed by this bill.
Of course. Okay.
Is that what you're?
And we just wanted to make sure that that was very clear,
Yeah.
because with that section, maybe that could be read differently
Yeah.
by a constituent or an individual who does not want their records, public at the Registry of Deeds.
Yeah.
And they may pursue that by saying that, well, subjectively, I'm concerned, and that the Registers of Deeds then would be subject to maybe that individual's, allegation that they're being harassed for having that.
That immediately in my head, I start thinking about people complaining that you don't know, I mean, we have to be able to know who owns our property and how much property tax they're paying to ensure that the other laws are being fulfilled. So hiding that information seems to me would be almost impossible.
Well, there's that concern that we have. So
Yeah.
I think to make it very clear, it would be helpful to have an exemption for the Registers of Deeds and their staff.
Thank you.
Thank you.
Wait, can we take a question?
Of course.
Representative Lascelles.
Yes, thank you for taking my question. Let's say there's a government entity that wants to buy a piece of property. But they don't want the public to know that this government entity wants to buy that piece of property. How would this bill impact that?
I'm not sure how it would impact that. I mean, I just want to make sure that I'm answering your question, correctly as far as what you're asking me. So if a government entity wants to buy a piece of property but doesn't want people,
The public to
the
know?
public to know, I think that would be difficult. I think there'd be certain ethical requirements. If it's a U.S. government entities, that's
Question.
I need to understand what you're trying to ask.
Okay, and my question is, do the Registry of Deeds have to disclose by law if somebody buys a piece of property?
everything that's recorded in the Registry of Deeds is indexed. The names are indexed as written on the document in the grantor and grantee index. So depending on what's on the document, that is what's indexed and that's what's open to the public.
Okay, and that's not related to this bill, so. Yeah, what do you want to say? Oh, go ahead, yeah.
Thank you for taking my question. I forgot to mention during my testimony that someone from the title insurance industry had also reached out to me about a proposed amendment. So if possible, I just wanted to read what they had suggested and see if it would address your concerns as well.
Great.
So for section A, they had just suggested taking out "or any part thereof" after home address. And then adding a line at the end of that paragraph, which would say personal information does not include information that is lawfully made available from federal, state, or local government records. And then another paragraph at the end that would say, for the purposes of this section, records made available on the internet by a state or local government official do not include records held by the property appraiser or tax collector, official records held by the clerk of the court, including the images and indexes maintained by the clerk of the court. Such records in the custody of the property appraiser, tax collector, or clerk of the court shall not be removed from availability to the public, altered, or redacted in response to a written request pursuant to this section.
What would be terrific is that in
Add
there to also
registry.
add Registry of Deeds.
Okay, perfect.
That would
Thank
be
you.
terrific. Thank you.
Thank you.
Thank you.
Is there anyone else wishing to testify in this bill? Seeing none, I'll hereby close the public hearing. 10:50. We got 15 minutes. What do you think about my bill? That doesn't get into all that. It makes it simpler.
just do yours, I'm fine with that.
We'll talk about it, and I don't know how much support I have, but
Excuse me, does the young chair have a prediction as to when we're getting out of here today?
Is that like the young Pope? Is that kind of, which is actually a very good series, by the way.
I put you above the young pope.
Thank you. I appreciate that. I want to we're going to try, we have a whole lot of bills to exec, so we're going to try and burn through as many, not late though.
Okay.
That's the best I can say.
How many think Nancy is still alive?
It's true. Could we please begin?
Welcome back. Representative Roy, your microphone is now working. See, it was the female magic touch. We are going to open the public hearing, or actually reopen the public hearing for House Bill 1366. And we welcome the sponsor to tell us about his legislation.
Good morning. Thank you. I'm Representative Terry Roy from Rockingham District 31. I am here bringing HB 1366 on behalf of and in cooperation with the Department of War and the State National Guard and military affiliates. This bill, it requires law enforcement, when they have a probable cause to believe a service member has violated a military order of protection, to notify specific military authorities. The intent is to ensure that civilian law enforcement communicates promptly with the appropriate military command structure when military protective orders are implicated, improving enforcement and victim safety in cases involving military personnel. That's basically all it does. So I'm happy to take any questions. There are experts here from the military and the various veterans organizations.
Hold on one second, Representative. Representative Roy, is this like almost as an extension to the bill that we passed last year, referring to if a person had a protective order that it would also carry into civilian land? Is this like an extension of that?
Yeah, this is actually an improvement on the bill we did last year. This is a effort on the Department of War to continue to focus on domestic violence and ensure that victims who don't fall between the two systems, the crack between the two systems. So yes.
Fantastic. Okay. Thank you. Representative Scher?
This may be a question for other witnesses, given your knowledge base, but has this been a problem?
Yes, actually it has, for many years. The two systems, while both of them work, they haven't always worked together. So when an order is issued by a commander in the military, that's the same as an order issued by a judge here, but it doesn't have the effect. So you understand, yeah. Thank you.
See no further questions. Thank you very much. Mr. Grady?
Yes, good morning, Madam Chair, ladies and gentlemen of the committee. For the record, my name is Kevin Grady. I am a 28-year resident of the town of Hooksett, New Hampshire, and I am a 25-year veteran from our Air Force. Today, I'm here representing the 20-member organizations for the State Veterans Advisory Committee. These names would be familiar to you. They're like the American Legion, the VFW. I personally represent the Air and Space Forces Association. And we're chartered by State RSA 115:A-8 to speak for the veteran community in New Hampshire. And one of the ways we do that is we look at all of the bills that are coming before you folks that we feel have veteran impact. And we take a look at the language of that, and then we come in and we get a position on them, and I come in and I tell you what that position is. We do support this legislation, and as Representative Roy said, it really improves on the work that was done last year by House Bill 62, if it's the one you want to look up. And that bill was amended in there to primarily say that you could use a military protective order to go to a civilian judge and get a restraining order. That was part of the evidence package that would be allowed to go forward to get a civilian restraining order. And this sort of improves on all that. This bill was signed by the governor on the 2nd of June, and it's in place. I wanted to just give you a little bit of perspective, and then behind me, the folks that are behind me are a little bit more experts on the nuts and bolts of how, the UCMJ works and other things. I was a squadron commander of a flying squadron in Panama City, Florida in the 90s. And at Tyndall Air Force Base, we had on-base housing, okay? And we also had barracks and bachelor officer quarters and things like that. So if I was confronted with a situation where we suspected that there was domestic violence in a house, then the tools available to me on the administrative side of the house, we've got an administrative side and then we've got a UCMJ side. On the administrative side, the thing that was available to me would be a military protective order. And when that happened, I can actually take the military member and say, you're not living at your house right now. You're going to live in the barracks while we sort this out, or you're going to live in the bachelor officer quarters. I could even do that if they lived off base. Here in New Hampshire, we don't have any of those facilities. All of our people live off base. So we're really reliant on those relationships between our military law enforcement folks and our civilian law enforcement folks. And I view this bill as just enhancing, saying that you all approve of those two people having better relations with each other, so we make sure that we protect the most vulnerable people in our population. And that's really all I wanted to say. Obviously, violating a military protective order, if we find out about it in the military, is a big deal. We move from this administrative side to now we're talking you violated an order. Now we're on the UCMJ side where you could actually go to jail for this. Okay. Sort of similar to, I doubt that too many judges are all that sympathetic to people that violate their restraining orders. And why would you be? I told you can't do this, and you did it anyway. So, so this bill really does, I think, build on that work and the relationships between civilian law enforcement and military law enforcement are really what's going to make this work. You're enabling it to happen, but those one-on-one individual relationships will be the ones that will make this work. And subject to your questions, really, that's all I wanted to tell you folks this morning.
Thank you very much. I think you covered
you.
it very well. Thank you.
you.
Ms. Willett?
Good morning. Thank you. So my name is Melissa Willett, and I'm the New England Regional Liaison for the Department of War. And it's my job to work with stakeholders like Mr. Grady, legislators such as yourself, state leaders, installation commanders on policy priorities that are negatively impacting service members and their families. And in this case, that is interpersonal violence. And I won't rehash everything that's already been said by Mr. Grady and Representative Roy, but there are a few items in my testimony that I'll skip right to that has not yet been said. So interpersonal violence can be defined as any behavior that asserts power or control over another person. While the Department of War has led the implementation of enterprise-wide guidance regarding the overall protection and prevention of sexual assault, interpersonal violence is a term that is intentionally broad to capture the continuum of harm that may precede sexual assault, domestic violence, abuse, and harassment. These instances of harmful behavior often involve personnel who interact both in civilian and military jurisdictions. And without coordinated communications, violations may go unreported and unaddressed, risking further harm to victims. Violating a military protective order is a serious offense and can lead to disciplinary actions under the UCMJ. This particular bill focuses on the roles of law enforcement officers and notification of a service member's MPO violation to the appropriate law enforcement agency, meaning the agency that entered the MPO into the NCIC database, and that's the National Crime Information Center database. So in this case, that would be the military law enforcement agencies, such as the security forces with the Air Force or the military police with the Army. Current Criminal Justice Information Services policy states that because local law enforcement authorities cannot take official action on MPOs, those local authorities are not required to notify the military authority that entered it into the NCIC database. According also to CJIS policy, for military protective orders specifically, hit confirmation is not required, as NCIC policy only requires hit confirmation when taking official action based on the order. And hit confirmation in these instances means the process of an agency validating a match found in the database to ensure the record is current, accurate, and in effect. Simply put, HB 1366 offers a framework to better support victims and hold offenders accountable while facilitating information sharing between both civilian and military law enforcement entities. And I'd like to thank you all for considering and contemplating this legislation, and Representative Roy for his continued support and advocacy on behalf of the Department of War.
Seeing no questions, thank you very much.
Thank you.
Mr. Ollis? I apologize. I wasn't sure what the title was, but I'm going to write it down so I remember for next time.
It's all right. I'm Major Ryan Ollis, the Associate General Counsel for the New Hampshire Army and Air National Guard. As a federal employee, I cannot take a position on this pending legislation. However, I do have a few words for the committee here to consider when deciding this piece of legislation. First, the New Hampshire National Guard General Counsel would respectfully request that the bill be amended to state the General Counsel or their designee in paragraph 2, section 2, to allow for alternate lines of communication. And Miss Nicole Desolate Bixler, the Deputy Adjutant General, can assist with that in writing. More or less, it's just to make sure that if he's on leave or unavailable, someone else can also take the call. In my current position, it would probably be me. The New Hampshire National Guard has a limited ability to upload military protection orders into the National Crime Information Center, NCIC protection order files that serve as a national registry for protection orders. Civilian law enforcement agencies have access to this registry and use it to track and enforce protection orders. Civilian law enforcement officers have no legal authority to enforce military protection orders. This bill, if passed, would enhance communication between civilian law enforcement and military and allow commanders to take appropriate steps to respond to the violation. Commanders may enforce violations of the Military Protection Order, MPOs, through disciplinary actions under the UCMJ or with administrative adverse actions to include administrative separation. However, a military protection order can only be enforced when the subject of the order is in a military status. This bill, if passed, does not change the enforceability of military protection orders that are violated when the subject is not in a military status. Commanders also provide support to protected parties after being informed of the violation and inform the protected party that they may seek additional protection under New Hampshire RSA 173B using the military protection order as evidence to ensure their safety, which was the bill last year. Essentially, what this bill does is allow commanders to work with and holds soldiers and airmen responsible for what they did administratively, or using the UCMJ when it occurs on when the violation occurs on a military status. If the violation does not occur on a military status, they still have administrative options, and they can provide support not only to the alleged perpetrator, but also to the alleged victim of the violation. Through behavioral health, through counseling. We have the Family Advocacy Program in Hanscom Air Force Base for both Army and Air, which handles domestic violence, and a number of other resources that are available. So by the command getting information from local law enforcement that there has been a violation, either through NCIC or through the victim informing them of the MPO, it empowers us to take some action and make sure that both the victim and the perpetrator are appropriately handled.
Great.
Pending any questions.
Representative Scheer.
Thank you. Do you have a copy of the bill in front of you?
Don't, but I can pull it up.
Well, I'm just thinking about your suggestion of an amendment to add or their designee. In reading it, I think you're referring to the section that reads the New Hampshire Air National Guard, New Hampshire Army National Guard, and the 157 Air Refueling Wing offices of the Staff Judge Advocate General, and you want to add it after that or their designee?
Yes.
So, given that it says offices of the Staff Judge Advocate, doesn't that take care of it? It doesn't have to be the judge, the actual Staff Judge Advocate. It just needs to be somebody from that office.
I would agree with you, except my position, in my position as the Associate General Counsel, I work out of the Office of the General Counsel, but my position is actually as the Integrated Primary Prevention Workforce Attorney, which is a separate office. And so by allowing him to have a designee, it would allow me to be, it would create clarification and allow me to be appointed.
So really what we're talking about, what we're talking about is a designee of the office.
Yes. Yes, sir.
Representative Sure, you all set?
Yep.
Seeing no further questions, thank you very much.
Still says office.
Is there anybody else here wishing to testify on House Bill 1366 that is not turned in a pink card? Seeing none, I'll close the public hearing.
Yeah. I gotta go to, introduce a bill. I'll be gone for a while, so. Nothing. That's not gonna change anything.
Want to point out this works. I'm feeling so proud. My perfect performance for the day. I
Okay, I'm open the public hearing on House Bill 1637, and I invite the sponsor to introduce the bill.
Thank you, Mr. Chair, and thank you to members of the committee. My name is Zoe Manos. I represent Stratham, which is Rockingham County District 12, and we are near Portsmouth. I'm pleased to appear before you today to introduce this bill. This bill comes out of the horrific murder of Marisol Fuentes in Berlin last July. After Ms. Fuentes' murder, the judicial branch and the AG's office each undertook thorough reviews to determine what steps could have been taken to avoid Ms. Fuentes' murder. What were the failures and what additional protections are needed to prevent tragic deaths or injuries to victims of domestic violence? This bill requires that when a motion to modify or revoke bail is filed by the state or by the defense in domestic violence, stalking, and harassment cases, the hearing on the motion shall be scheduled within 72 hours, excluding weekend, state, or federal holidays. It does not require that the hearing be held within 72 hours, but only that the scheduling of the hearing occur within 72 hours. This would avoid an inordinate amount of time to pass between when a motion to modify or revoke bail is filed and when a hearing date is set. Escalation can happen very quickly in cases of domestic violence, stalking, and harassment, and it's critical in this situation that the prosecution and defense can get a hearing date scheduled quickly. In Marisol Fuentes' case, a second victim came forward separately, a minor who was 17. She alleged that the defendant had sexually assaulted her after criminal bail conditions had been set in the assault case in which Marisol Fuentes was the victim. The prosecutor then would have had to consider whether to ask the court for a modification or revocation of bail. A hearing on a motion to modify or revoke bail must be scheduled within a short period of time. Otherwise, the defendant will potentially continue to injure or kill other people while out on bail, as happened in this case when Marisol Fuentes was murdered by her abusive husband. I've spoken with Patricia Conway, who's the Rockingham County attorney, and I believe she's supportive of this bill. Thank you, Mr. Chair, and I'm happy to take your questions.
Thank you. Do you have any data or numbers on as far as supporting the need for this with delays in domestic violence cases getting hearings?
Well, they certainly, if a motion to revoke or modify bail were filed either by the prosecution or the defense, it would get scheduled. But the point is here that there's no requirement that the scheduling of the hearing get done quickly. And so there can be delays in how long it is before the hearing is scheduled, and then, of course, what the hearing date would be.
Okay. All right. Representative Mears.
Thanks for taking my question. So basically what we have now is a situation where any judge can define what constitutes promptly. And what your bill is basically trying to do is to get more specific, to put specific guardrails into the statute that actually defines the allowable timeframes.
The allowable time frame of the scheduling of the hearing.
Yep. Thank you.
And if I may just add, I think what's critical here to understand is that escalation in domestic violence cases or stalking cases or harassment cases can occur very, very quickly, as we saw in this particular case, but as we know in general. And when there are delays in the scheduling of the hearing, that is allowing for additional potential harm to occur.
Thank you.
Seeing no further questions, thank you very much.
Thank you.
Anyone else wishing to testify on this bill? Well, I think we do, maybe. Yeah, I do anyway. Yeah, it is.
Good morning, honorable members of the committee. My name is Lauren Warner, and I serve as Deputy General Counsel for the Judicial Branch.
Thank you, General Counsel. So, a couple questions. Does the prosecution have the ability to make an emergency motion to come forward immediately to revoke bail on a dangerous subject?
They can certainly file an emergency motion, yes.
Yes. And that would generally be heard quickly. Is that-
Yes.
Okay. Second question. Someone who, in the case that we just heard about, where the person committed another crime while on bail, and we were told that the prosecutor would have to then go forward and make a motion to revoke that bail, and that could take time. That would qualify as an emergency. They could file for an emergency motion, correct?
The prosecution has the ability to file at any time and note it as an emergency, but also.
I see. I don't want to lose my train of thought because I'll never find it again. I thought so. And furthermore, the police have the authority to, if you're able to answer this, to arrest someone on a new crime, which would bring them before the court right away. Anyway, is that not the case as well?
I wouldn't be able to speak to any of the police prosecution or their ability. I assume yes, ability to arrest on a new crime, but
Well, the
as
court
noted-
has seen people brought in on new crimes, correct?
Yes, but I think that is certainly noted in this bill. As the sponsor said, it's simply requiring the scheduling to happen
Yeah.
within a period of time as opposed to the actual hearing to occur. So the judicial branch certainly doesn't have a concern in
About
any way on this bill. And I think noted in, or I don't believe since there was no fiscal impact, the
Yeah.
judicial put in this fiscal note, we could assume take on.
How long is it taking now? I mean, does this?
I don't have the time. I would have to look.
Yeah.
I would have to pull statistics to find
Well,
out
what
how
I'm
long
concerned
it's
about, if they're generally getting scheduled within 48 hours, I don't want to say now you got 72 hours, if we're already going pretty quickly. So how long would it take for you to get that information?
I can reach out to see if that information is available to determine when it was filed and when it. I
Just about
sorry, I
how long
can't
it
speak
takes to get it scheduled. That's
yes, but I would certainly note that if it said that shall be scheduled within 72 hours, I would have certainly assumed the branch would make every expectation to continue to schedule as quickly as possible, but would
Yeah.
not allow them to schedule beyond the 72-hour time frame.
Okay, thank you. I appreciate if you could just get back to me.
Yes, yeah, I'll find out.
Representative Scheer, did you have?
Yeah, in the vein of your second question, if somebody's out on bail on a charge, if they're arrested for a new charge, at the least they'll see a bail commissioner, right?
Correct.
And the bail commissioner would be aware of the fact that or would be made aware of, may already be aware of, that they were already out on bail on another charge, right?
They should be, yes.
Thank you.
Seeing no further questions, thank you very much for being available to us. Is there
Welcome.
anyone else wishing to testify on this bill? Who hasn't? Seeing, I close the public hearing. And please don't take our questions as any disrespect to your bill. We're just very cautious of bail because we have done so much work and some of it is just now taking effect. So okay, thank you. With that, let's take 11 o'clock. Do you guys want to just take lunch now or would you rather just caucus and?
I have to present a bill at 11:30. It'll take no more than 5 minutes.
All right.
So whatever we do, I won't be around.
All right, let's do this.
Let's keep
Well, you
caucus.
have to, yeah, but you have to leave. Yeah, yeah. So,
Let's caucus. Let's exec for a while.
we mean right now? Why don't we take a 15-minute caucus break so we can just go over our bills and see what we got and.
Do we have an order in which we're going?
No, the order is the clerk gave me a sheet of all the bills that are outstanding, so I'm going to just breeze through them and look at the ones that I think that we can just knock out without any kind of.
Is that list in numerical order?
It looks like it is, yes.
Compliments to the clerk.
Yeah, indeed, always compliments the clerk. So 15 minutes, we'll start up and we'll exec until 12, and then we'll take lunch and come back. Actually, you know what? Let's just exec until like 12:30 and we'll call it a day. And then we'll come back Friday and see what we can take care of. Does everybody agree with that? All right. See you in 15.
For the record, we're,
opening the executive session on CACR number 19. And I recognize myself to make a motion. I am moving inexpedient to legislate.
I'll second.
I will speak to my motion. This is another bill to try and legalize marijuana. We have had, I can't even count how many in the last 6 to 8 years. None of them pass, most of them don't pass the Senate, and none of them pass the governor's office. I agree with the policy decision to try and legalize marijuana through laws. If we can convince enough of our representatives and elected officials to pass those laws, but we haven't even had enough elected officials to pass the laws. To pass a CACR, we need to get 2/3 of all of our legislators and then the public. And furthermore, even if we were successful, do we really want to permanently enshrine one drug in our Constitution? And what happens to it if it gets modified and it gets even stronger and it becomes even dangerously deadly? It's in our Constitution. To regulate it, we would then have to change that. It's such a path that is fraught with peril. So that's, for those reasons, I am recommending inexpedient to legislate. Who made the second?
I did.
Would you like to speak to your second?
No, thank you. I think we're good.
Representative Muse.
I'm going to support the motion, and the reason is even though I support cannabis bills in principle, I don't support cluttering up our Constitution with stuff like this. That's the bottom line. It's one of the reasons why we get paid $100 a year and we can't get it changed, is because somebody decided to put something trivial into the Constitution 100 or so years ago, and we're stuck with it because we can't get it changed. And so for exactly the reasons Representative Roy cites, I support the motion to ITL this.
And I would just add that if they'd have said $100 in gold, I think we'd be doing good today. If that, yeah. Representative Murray.
Thank you, Mr. Chair. I will be opposing the ITL motion. I, completely understand the legislative history when it comes to cannabis legalization, but this is one of these issues that the public brings up to me over and over and over and over and over again. And I think with the CACR, yes, it will be harder to pass through the floor, but it is the most direct way where we can put this decision in the hands of the people, which I think is where it belongs. So I will be voting against the ITL motion.
Thank you. Further discussion? Seeing none, I would ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative Lascelles?
Yes.
Representative Devoid?
Yes.
Representative Paquette?
Yes.
Representative Saborn Deschwinier?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes no. Representative Scheer?
No.
Chairman Roy?
Chair votes yes.
11-2.
11-2, it can't go on consent because of the 2 no votes. So I'll need a minority report from one of you by Sunday evening, please. Uh-huh. Okay. With that, I close the executive session.
So would the minority motion be OTP?
Yeah.
So let the record show that this ACR was one toke over the law.
Oh, sweet Jesus.
And you think I'm bad.
Yeah. Old people should be careful. All right. For speed purposes, I'm going to open the executive session on HB 1034 relative to the possessions on firearms on school property. And I'm recognizing myself to make a motion. I move inexpedient to legislate.
Second.
Prue has it.
Seconded by Representative Prue. I'll speak to my motion. This bill, I understand the intent. It's public safety, and the sponsor believes that this is an appropriate way to do so. I and my colleagues disagree. We think that the current law with regard to school property is that you can't go on school property unless you have a license to carry a firearm per federal law. And if you have such a license, you have been submitted to a background check and are presumably not a prohibited person. School shootings that do happen, people already ignored the law by bringing the firearm on there and then using it unlawfully. So adding this law will just disarm people that are legally allowed to. In our opinion, the law is unnecessary. Would you like to speak to your second?
I agree that this is unnecessary. We already have things in place, like you stated, that you have to have a license to carry to go on school property. So I don't need to keep creating gun-free killing zones. Thank you.
All righty. Representative Muse, I know you're going to have to.
Yeah, I'll be supporting, I'll be actually opposing the ITL on this bill. Um, you know, we have, we reached a point a few years ago where we actually did manage to pass a bill like this, and it was vetoed by the governor. We've been very fortunate in New Hampshire that we haven't had an incident like a Parkland or a Newtown. And one of the things that I'll continue to say is that there is no magic bullet when it comes to preventing incidents like this. Our task isn't to find a magic bullet. It's to actually do things that will substantially reduce the risk of incidents like this happening. And if you reduce the risks enough in different areas, you can make a real difference. And one of the things that I will say, and I know I've said this a couple of times this year before, but there's no group of people that is more sober than a group of legislators after one of these incidents has happened. So my feeling is that the more we can do to try to prevent something like this, I think the better off we are. And one of the issues we have is that currently our local law enforcement people can actually enforce the federal school safety zone law. And I've been told that by my own local police chief. So this bill would get us started down that road, and I oppose the ITL.
Thank you. Further discussion? Seeing none, I ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschrenier,
Yes.
Representative Harriet Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Shear,
No.
Chairman Roy,
Chair votes yes.
7-6.
7-6, motion carries inexpedient to legislate. I close the executive session. I open the executive session on HB 1047 and make a motion of inexpedient to legislate.
Second.
Wait a minute, did we? It's not, see, this is the clerk gave it to me and it says in committee that we haven't.
That's right.
No, are you sure?
No, we did.
Okay.
We did. I don't have the sheet.
Yeah, but. Okay. Well, I was about to redo the exact same thing. At least I'm consistent. All right, so we'll research it, but assume it's done. Everything I just did was then invalid. The bill is no longer in the possession of the committee, so it doesn't matter. If I am incorrect, huh? Okay, if that is the case, then we're fine. If not, I'll bring it back Friday. I'm going by a list the clerk gave me yesterday, so. All right. I'd like to say so, but he probably would say, no, not this clerk. The clerk. Okay, skipping right along. House Bill 1048, relative to the possession of brass knuckles. Actually, no, we're going to wait on that one till Friday. Notify yourselves Friday. I'm going to bring that. I'm bringing an amendment to make it a little more interesting than the usual one we get. Yeah, so that's not opened. Next one, House Bill 1049, relative to the storage of firearms. I'm opening that one, and I recognize myself to make a motion. No, I do not. I recognize Representative Saborn Deschrenier to make a motion.
Thank you, Mr. Chair. I move that we HB 1049 be an expedient to legislate.
Second.
Seconded by Representative Prue. Would you like to speak to your motion?
So this bill requires firearms to be securely stored in homes and locked. I don't see how this can be enforced other than after the fact if there's an incident at home. So unnecessary.
Thank you. Would you like to speak to your second, Representative Prue?
I find it makes it hard for me to do my Second Amendment right in my own house. So I know when I need to lock up my guns when my grandkids come over, and I know when I don't need to lock them up. So, and I don't need a law for that. Thank you.
Thank you. Representative Muse.
What this bill does is it actually sends a pretty strong message to reinforce exactly what Representative Prue said. If you have kids coming into your house, your guns need to be locked up. What it does is it turns it from a suggestion into statute. And there are some other things in there as well. Currently our firearms negligence statute essentially is a no harm, no foul statute. So basically, if a child gets a hold of a gun, there's actually no violation of the statute unless the child shoots somebody or threatens somebody with it or commits a crime with it. However, if a student, let's say, walks into their elementary school with a gun in the backpack and then shows it to a whole bunch of other students, then that's not considered negligence unless the student actually goes and shoots one of the other kids or shoots himself. So the bottom line is our law, while it does do some things that are protective of children, could do a lot more, and that's why I'd like to see us pass this bill. Thanks.
Thank you, Representative. I have a question. Civil liability purposes, what is the current state of the law? And Representative Scher, if you can chime in as well. If I leave a firearm unsecured and a child, whoever, nephew, niece, neighbor, whatever, grabs it and does take it and brandishes it or whatever and hurts somebody, the law does not prohibit somebody, the victim, from civilly suing me for leaving an unsecured firearm, does it?
It does not.
So I could be sued. Okay. And I could be charged, could I not, under some?
It's a messier reckless conduct charge. It'd be messy.
Yeah.
It's not a great.
So perhaps we do need a clearer law as far as responsibility to the person who did leave an unsecured firearm. And I'm happy to look at that in the off season, not right now in election year. Anybody else? Representative Scher.
Bill is not directed at the Representative Prus of the world. It's directed at having consequences for stupid people who have firearms. That's the point of the bill. It's, you know.
I agree. I understand it's about Darwinism a little bit, but the effects it has on people who weren't stupid, who just happened to be existing. And I understand that. And I think that there are ways to look at that, but I don't think that not ensuring, but mandating that all people act a certain way because a small portion of those people are stupid is how we should legislate on any subject, especially fundamental rights. But
Just to be clear, this is no reflection on the intellectual capabilities of Representative Prue.
No, I don't think any were taken, were they? See no further discussion. Yeah, I tried.
I appreciate you pointing out that I have some mental capability, but I will.
I actually didn't say that.
I'm going with it, okay? If we made laws to try and fix stupid people, we would have so many laws, we wouldn't even know what to do with them, and the stupid people wouldn't even look at them.
And I dare say many of us might not be here. With that, please call the roll. The motion is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Scher,
No.
Chairman Roy,
Chair votes yes.
7-6.
7-6, the motion carries. I close the executive session. Up next. Okay, so what's next? I open the executive session on House Bill 1058 and recognize myself to make a motion. I move inexpedient to legislate.
I'll second. Sorry, Madam Clerk, second.
seconded by Representative Rhodes. I will speak to my motion. This bill would allow someone to carry a long gun on a ATV with a round chambered in battery. What? It's possible. Don't let me get far if we already did it.
I remember hearing this speech. And,
Yeah.
and Representative Tulersky was sitting next to me, and we chatted amiably about your speech. I think we've already done this, Bill. I think
Yeah.
we ITL'd it 12-0.
Well, it's like Groundhog Day. Okay. So everything I just did, including banging the gavel, was without force or effect because the bill is no longer in our possession. All right, we're cranking these out. So what's next? 1061. Anyone know if we did that one yet before I open it? Oh, we still have that. Okay. Yep, we do. And I will open 1061 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 1061.
Second.
Seconded by Representative Prue. Would you like to speak to your motion?
I would, and I say this with all respect to our Madam Clerk, and I do understand the reasons for having this bill. I understand the reasons why it came to us. I think last year is just a straight up bill. Now it's looking to be a commission. There are a few bills that we hear that I think that I actually like less than this one. And I just think that this is creating selective enforcement. I believe that is going to lead to social coercion. I think it's going to lead to discrimination. I think it's going to lead to confusion. And ultimately, I don't want to give the effect that it's okay, to have punitive punishment for some people, but not all people for the exact same crime. That's it. And there's obviously a lot more that I can say. I don't really know that it's necessary. And I understand that's already being done, but that also even bothers me. So that's my motion.
Representative Prue, would you like to speak to your second?
I'm good, thank you.
I would just add, Representative Rhodes, I agree. I don't, my experience is, and I have seen criminals utilize statutes like this. For example, someone who's notoriously or has a felony offense and not allowed to carry a firearm will have their girlfriend or their wife hold their gun. They will do same thing. Drug dealers are known to have their woman, female, or partner, regardless of sex, who's a caregiver for the family, carry their drugs because they know that they will, if sentenced, will be sentenced to a lesser amount of time. And that's not even in statute. That's just based on a judge's or a jury's sympathy for the person. Putting it in statute, in my opinion, is almost saying that behavior is recognized and approved by the state. I just feel like everyone should face blind lady justice the way that the most way, and I know that that's not what occurs, but we should be striving to make sure it does. So that's all I have to say. Representative Murray, would you like to speak to you? Well, it's her bill, isn't it? I'll let her go first.
Thank you, Mr. Chair. I think these points have been recognized, but just to reiterate, this is to establish a commission, so it's not changing any existing laws. The judiciary already has the ability to consider whether someone is a caregiver or not when they're sentencing for this specifically relates to nonviolent offenders as well. And the reason, the impetus for this is because this was brought originally forth as legislation multiple times that would change statute. And after talking with multiple stakeholders who would be named to this commission, they were all willing to meet and be a part of this commission to discuss how we can arrive at a conclusion that would work for statutory changes. I guess the point further I'd like to make is when we have people who are primary caregivers, I do think it's necessary to weigh what the consequences are on the people around them, the people that they are responsible for taking care of when they're incarcerated. Again, especially for this is regarding only nonviolent offenses. I cited a lot of data in my original testimony, but we know for a fact that when a parent is incarcerated, it has extremely negative impacts on the children and kind of almost ends up creating a second generation rehabilitation of potential criminals. And so I think it is important, if we're looking at creating a society that's safer for everyone and focused on rehabilitation and focused on improving public safety for everyone, that we are weighing the effects that incarceration has on the rest of these family members when we're taking someone who's the parent or the breadwinner and separating them from their kids and potentially putting those kids into the foster care system. So this wouldn't mandate anything other than, like, I mean, first of all, it's just a commission, but.
Thank you. Representative Murphy.
Thank you, Mr. Chair. I'm going to support this bill this time, but because it's a commission. But I have, as I mentioned last time when this bill came before us, I feel like the courts already have discretion, and I'm a little concerned, even though I know it's nonviolent, I'm not sure that that carve out makes sense, as I feel like, I don't know, just my history with DCYF and working with families, I would hate to see this used as, you know, a not sort of a get out of jail free card, and it makes me worried. So I would support the commission because I think, you know, maybe I'm just the only one, but I think, you know, whatever would come out of the commission would see, you know, where the support was or not. So I'll be voting yes, but
With reservation.
cautiously.
Representative Scheer.
I feel about as strongly in favor of this bill as anything we've seen this session for this reason. Bear with me. I've been involved in the criminal justice system for 45 years in New Hampshire. And I know, particularly with people who are of very limited financial means, which are the people that I over 2,000 of them that I represented for over 13 years. I know the effect that incarcerating a primary caregiver has, number one. But more broadly, I know how we've got to figure out ways other than money and jail to deal with with a lot of people, because, you know, money for the people I used to represent, it just puts them in debt. It puts them further underwater. For people who, and it hasn't stopped people from committing crimes getting fined. People who get a jail sentence, particularly with primary caregivers, it really has a tremendous rippling effect throughout their life and through their family's effect. I appreciate everything that Representative Rhodes, the chair has said, but it's exactly because of what you two have said that we need a commission. We need to figure out a way to sentence these people that they feel in a way that might encourage them not to engage in that behavior again, but doesn't put them even farther underwater financially and doesn't ruin their family circumstance. And it's exactly because of what you two have said that we need a committee. We need to have people start to sit down and talk about it and try things out rather than just putting our heads in the sand. So I can't say that I felt more strongly about something than this.
Thank you. Representative Murray.
Thank you. The other thing I just wanted to mention in my conversation with stakeholders is, so the purpose of the commission is because in the past, when we brought this legislation forth, there was a concern that we didn't have the right programs and support infrastructure in place to make this kind of sentencing happen. And so when I was talking with stakeholders about creating this commission, we spoke about how this kind of research and conversation is going to support not just this one intention, but in general, the structures and support systems we need to invest in and build out in order to address the support that is necessary for families that are going through DCYF or all these other cases. This will help us identify where some of these existing gaps are and what exactly the solutions are. So the impact is greater than this one specific intent as well, because it has a broader, set of issues they'll be looking at.
Thank you for that clarification. Seeing nothing further, I'd ask the clerk to call the roll. The motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Shear,
No.
Chairman Roy,
Chair votes yes.
7-6.
7-6, motion carries, inexpedient to legislate. Next bill I'm going to open is House Bill 1084, and I recognize myself to make a motion of inexpedient to legislate.
Second.
I'll speak to my motion. This is a bill that speaks to the relinquishment of firearms by people who are subject to a domestic violence protective order, and it talks about would change the law to the extent that it would make a law enforcement officer serving a order be able to immediately confiscate the firearms of somebody who possessed the firearms versus the current statute. I believe the intent, and I'm sure he'll tell us, is to quicker get the firearms away from someone who has been the subject of an order. And I believe that's already happening, but I'm open to hearing from the sponsor as to why he thinks that isn't happening or this bill would change it. But it's currently our opinion that this wouldn't necessarily change the law in a positive way and may infringe on Second Amendment rights. Who made the second? Representative Prue, would you speak to your second?
I'm good.
Okay.
Thank you, Mr. Chairman. I believe, and I do apologize, I don't have that bill in front of me, but I believe a lot of the testimony that we heard regarding this was that this was before a public hearing, if I'm not mistaken. And I also believe that it was like you had 30 minutes, I believe, was to present for the defendant to actually present a case, which I just don't see any real logical world where that can actually realistically happen.
Thank you for filling that in. Representative Muse. It's his bill, that's right. Is it your bill?
Thank you. No, I would like to speak on this one. I will, to address the point you raise, Representative Rhodes, the part, what you're talking about isn't something that is actually part of my bill. That's actually part of the domestic violence statute currently. So my bill didn't do anything to change that one way or the other. What I'm trying to do here isn't just to change the law. I'm trying to change outcomes. So currently, about half of the homicides in our state are domestic violence related, and about half of them are homicides where firearms are involved. We are not going to be able to pass a law that's a magic bullet. But taking a look at our domestic violence statute, one of the things that we do have an opportunity to do is to put more structure and more guardrails around the firearms relinquishment process. And this bill does exactly that. There are a lot of areas in the current statute that are ambiguous. We're one of the few states that doesn't actually specify a time frame under which firearms do need to be relinquished. And in the absence of clarity, one of the things that can happen is things can fall through the cracks. And I think, we all understand, what happened last year up in Berlin was sort of a symphony of things falling through the cracks. And unfortunately, we have a woman who's dead as a result. She's not alone. She is not the only person in New Hampshire who died in a firearms-related domestic violence incident last year. The idea here, again, is to really reduce the level of risk for people who are under this threat. This is really it's not an anti-Second Amendment bill. It's a pro-victim bill. And I think what this bill tries to do is to keep more people like that alive. So I'll be opposing the ITL motion.
Thank you. Representative Scheer.
Just to follow up, this isn't a anti-Second Amendment bill. The law already says that those firearms have to be relinquished. It just makes it happen quicker in a very narrow set of circumstances already established by the law. And it would have, there's a lot of different legislation regarding what happened up in Berlin, but this perhaps more than anything that we've seen so far would have made what happened up there less likely.
Thank you. I'm not sure about that. I think that had the person not been released, that's the primary reason that poor woman is dead, is because there was a failure in our system that had nothing to do with the firearms, more to do with the fact that that person had no business being out of jail. And this committee worked really hard and spent a lot of money so things like that wouldn't happen. And as I spoke earlier, we are going to find out what exactly happened to that money, and is the system been fixed? I know that this tragedy occurred before some of our bills that we passed took effect, and I'm hopeful that that changes would prohibit something like this from happening again. But I am still committed to sending a letter to inquire as to what happened to the electronic system we demanded to be changed. Representative Scher.
Yeah, just to follow up on that, I think it would be helpful if the entire committee signed on to that letter. So if you could circulate it so we can all agree to it.
Agreed. And I'll work with you to draft it, and we'll get it around. Okay, back to this one. Seeing no further discussion, I'll ask clerk to call the roll. The motion is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
okay. Representative Harry Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy.
No.
The clerk votes no. Representative Shear,
No.
Chairman Roy,
Chair votes yes.
7-6.
7-6, motion carries and expedient to legislate. I close the executive session. What do we got left? 11:08?
Yep.
Where is it?
It's right here.
I'm going blind. No, it's not. Okay, I'm opening the executive session on House Bill 1108, and I recognize myself to make a motion of inexpedient to legislate.
Second.
I'll speak to my motion. This law, or this bill, would increase the ability of someone to brandish a firearm during a perceived altercation. I read the law of the bill. I read the law. I reread the bill. And I do not see where it's necessary, and I do believe it would lead to dangerous situations. Part of being a Second Amendment advocate and a firearms owner is being a responsible and safe firearms owner. And I don't think drawing a firearm under any conditions where you do not perceive the need to use deadly force or the legal justification to use deadly force, it should be authorized. Firearms are not talismans. They're not something you use to intimidate, or they're used for a specific purpose, and that is to use deadly force. This isn't the Wild West. We're not having gunfights, and we're not, winging people to slow them down. We're not, none of those things. Firearms should not clear the holster unless you are prepared to use deadly force. And if you don't have a legitimate reason in front of you where you might need deadly force, the firearm should remain holstered. I feel like bills like this are only going to lead to further restrictions on the Second Amendment because they're going to lead to predictable tragedies. So I can't support it as much as I respect the intent of the sponsor. Would you like to speak to your second?
Yes, thank you, Mr. Chairman. I just want to be very clear where this says perceived by a reasonable person. I made the joke earlier today about my friend from Portsmouth and I, how he's, flies off the handle and I'm perfectly calm at all times. But at the end of the day, that is a very, very subjective word, very subjective. And you can't make it be okay in one piece of legislation, but not make it be okay in another. Thank you, Mr. Chairman.
Thank you. I would like to just follow up on that. The Supreme Court of the United States doesn't like reasonable person. In several cases, I believe they have said so. They do like narrower, in other words, a reasonable police officer. In other words, someone similarly situated with specific experiences and specific training. But when you say reasonable person, that just opens it up to, almost 3 million people, the whole world. How do you determine what's reasonable? So that is almost impossible. And the courts have clearly said they don't like that. So for us to just kind of toss that out there and say, you figure out who's reasonable is both shirking our responsibility and in my opinion, borders on unconstitutional. Representative Scheer.
I will vote in favor of the ITL because this is what I call an escalation bill. It creates a situation that escalates things rather than de-escalates things, and that's just not what we want.
To your point, we are New Hampshire. I like to say we're a well-armed society. I mean, there's no restriction on anyone who should have a gun having a gun. So by drawing a gun, you can presume that the other person might have a gun as well. And to your point, now 2 guns are out. It's a nightmare for law enforcement as well to have to show up to scenes like this and determine who's the good guy, who's the bad guy. It's not necessary. If you feel your life is being threatened and you can articulate that, then by all means defend yourself. But when you can't articulate that firearm does not have any business out of your holster. Representative Shaborn Duchesne.
Yeah, I think I want to point out that some of the incidents that inspired this legislation in the first place actually occurred in another state, far away from here. Laws are different, culture is different, situation is different.
Thank you. I agree. Representative Murray.
Thank you, Mr. Chair. Yeah, I will be voting to support the ITL motion. I think we've been, some of us have referred to this as the road rage bill. And as someone who has had a gun brandished at them after accidentally cutting someone off, and also have witnessed the aftermath of someone getting shot in a road rage incident, I completely agree with my friend from Portsmouth that this is an escalation bill and it only makes our roads more dangerous. And I absolutely do not think we should be empowering people to bring firearms into what are often minor traffic arguments.
What about your friend from Deerfield? I didn't get any recognition of that. Just the Portsmouth guy.
Seems that I'm everybody's friend.
You know what's very sad is that very soon my son may be one of your students.
I will point out for those of you who didn't hear this, Major Olis was also
We heard that.
I
Thank
just thought I'd say it 2 times.
I'd ask the clerk to call the roll. The motion on the floor is an expedient to legislate.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative Lascelles?
Yes.
Representative Devoyd?
Yes.
Representative Paquette?
Yes.
Representative Saborn Duchenier?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Scheer?
Yes.
Chairman Roy?
Chair votes yes.
13-0.
13, sir. Any objection to consent? Seeing none, it will go on consent for a few minutes. And close the executive session. I open the executive session on House Bill 1142 and recognize Representative Prue to make a motion.
I make the motion of ITL.
Seconded by Representative Rhodes. Would you like to speak to your motion?
Yes. So I see this bill as something that may need to be put into place at some other state far, far away that things are very different. Sounds like a movie thing, but I don't think we're going to need this in New Hampshire, at least not anytime soon, because we deal with things a little bit different. Law enforcement's, I believe, is different, and I always look at what if they need to. What if it's cold out and they need to put something up? But they already wear their badge. They have their name tags on. I don't think we need this.
Thank you. Would you like to speak to your second?
Thank you, Mr. Chairman. I would just say that I know that there seems to be, over the years, a lot of knee-jerk reactions when something is happening on the other side of the country, and creates this ripple effect that we here in New Hampshire have a problem that we do not have. And I think this is a perfect example of one of those. And I'm also reminded of the 2018 bail reform that we spent 4 years trying to undo. And that's all I have to say.
Okay. I would just add that I agree. This isn't happening here. We're not having ICE raids. I haven't seen one video story on the news of this happening in New Hampshire. Well, at least ICE raids where our officers are part of it. We don't have the population centers like some of these other cities where huge assistance from law enforcement would be required. I don't want to import problems where we don't have any problems. And I will reiterate that there is a danger. You know, some people scoffed at it and said, well, there's no danger. They know what that's the most horrific thing I saw was someone saying, well, they knew what job they signed up for. People are identifying these officers. They're going to their hotels and kicking in the windows, trying to get to them. They're identifying them and doxing their home addresses, their children's schools. It's insanity. So until we can protect our officers and their family, I'm not going to support restricting anything that they need to do to make sure that while they're carrying out the laws we ask them to carry out, that they're not risking their families' lives to do so by having to show their name and face in some certain circumstances. Further discussion. Representative Murray.
Thank you, Mr. Chair. It feels so, don't even know how to contemplate or understand the fact that in the live free or die state, we would be fine with officers coming up without their name and covering their face and saying that you have to comply and get in a van with them. And I agree that I have not seen the level of ICE raids that we're seeing in other states across the country. Just because it hasn't happened here yet doesn't mean it won't. But regardless of that, we have over a dozen local law enforcement agencies, including the state police, who are in these 287G contracts with ICE. And so if they wanted to, or if they're requested to by ICE, they can engage in these raids. And so I don't know why we wouldn't require our law enforcement or encourage them to do what they're already doing, which is identify themselves and remain unmasked. Again, in this state in particular, I think it is so important to continue to assert our constitutional rights to know if we are submitting to law enforcement that person is law enforcement, and the person's, the individual's potential personal risk does not, in my opinion, outweigh our constitutional rights to, again, know that if we're being taken into custody, that is being done by a law enforcement officer. Especially, we have seen cases across the country that are starting to happen more and more where random people are just throwing on masks and going to grab someone, and who knows if they're a law enforcement or not, because law enforcement is not currently identifying themselves. So again, I know that maybe this is not a problem we're seeing here yet. I do know our local law enforcement to be, upstanding, law-abiding people that, to my knowledge, do identify themselves. And I don't know why we wouldn't encourage them to continue to do so, whether they're engaging in immigration enforcement or not. I just can't imagine submitting to someone who's saying they're law enforcement without them proving that. And I also think that's for the safety of law enforcement, right? Like we just talked about how many people are armed in the state. Someone should have to say that they're law enforcement, just even for their own protection, and make sure the person knows that they can't, physically defend themselves against this person who's showing up with a mask in a dark car with dark windows and telling them they have to get in. I was always told not to go into a van with strangers.
Is there candy involved or? Representative Scher.
Representative Murray said a good bit what I was going to say. We have had 3 ICE raids in Portsmouth since January of last year. The first one, it was exactly that. It was masked people armed in black clothing and a black van. And the police department got a call saying, I think somebody's being kidnapped. This was early in the ICE phase of our lives. And, that's Portsmouth Police Department has not signed a 287G agreement, has no intention of doing so. I think this is two things. One, what Representative Murray said, it is for the protection of the officers. I think that is an understated thing, number one. And number two, police officers in New Hampshire for decades have not been masked. And they've dealt particularly with those working on the statewide federal state drug task force. They've been dealing with very dangerous individuals.
Just to correct you, they do wear masks on raids that are dangerous, that involve SWAT teams kicking doors if it's a known narco-terrorist type situation. So they do in some limited circumstances.
In some very limited circumstances, but the officers I've talked to is when they're arresting individuals rather than a big raid, they are not wearing masks. New Hampshire officers have not had a problem with doxing or threats, and it that I've ever heard of. And I checked with my chief on that. So I think what is being lost is I think it's important. Some may disagree. I think it's important that we say to the citizens and the residents of New Hampshire, we're in favor of allowing for accountability if something bad happens. That is an important message for us to send. Thank you.
Representative Paquette.
I just wanted to add something. I had a conversation with a police officer who is, his work is being involved on a task force, and they do a lot of plainclothes work. And they do show up at situations, from what I understand from this conversation, is they do show up at these situations where there's, SWAT or, other things, and they do need to protect their identities so that they continue to do the work that they do. So this person that I spoke with felt that this was going to seriously impede the work that they do. Along with that, he had mentioned about, having to identify themselves and, people that are undercover, on some of these task force. I think that really kind of impedes what they're doing as well.
Thank you. I just want to clarify what you said. So law enforcement often has dual roles. So you can be a detective and do undercover work and do buy busts and things like this. And you can also serve on the SWAT team. And to your point, such an officer would want to hide their identity, not from the general public, from the specific target of the warrant, who would be able to say, hey, that guy's a cop, and their undercover part of their career is finished. So it puts them in an awkward position. Representative Scher.
This legislation doesn't address that situation. It just deals with immigration circumstance. That's it. It doesn't change those circumstances where they're going in a SWAT team or otherwise. It only deals with immigration.
Representative Muse.
Something we haven't talked about is the possibility that that some ICE agents could actually pressure a New Hampshire police officer to wear a mask on some of these raids, or to not identify themselves. If they're not doing it, my guess is they wouldn't be upset if our police weren't doing it as well. So I mean, in part by having a statute like this, we really take that off the table. You know, our local law enforcement officers can say, that's not only something we don't do in New Hampshire, it's something we passed a law to keep us from doing in New Hampshire. And in terms of, you know, our to a certain extent, I think New Hampshire's small size and relatively small population doesn't necessarily give us immunity from bad things happening here. I think what it does is it makes them maybe a little less likely that they'll happen here. But simultaneously with this, there are things that are happening in our state, you know, that could make these scenarios more likely. And a big one is what appears to be happening in Merrimack with a 1,500 person detention facility that's actually going to have room for tents outside. That's part of the application. So we could conceivably be talking about not only a lot of people being processed through New Hampshire who are coming in from other states, but one of the ways you keep a large detention facility like that going in an operation is, well, maybe you increase enforcement actions significantly in our state, in places like Manchester and Nashua. So the bottom line is it can happen here, and this is a very, very small, narrow bill. It really only affects our police officers, our law enforcement officers. We can't tell ICE what to do, but we can direct our own police officers. And I think when people encounter a New Hampshire police officer, they expect to encounter somebody who's willing to identify themselves and who's willing to show their face. That to me, that doesn't seem to be like a heck of a lot to ask.
Thank you. Representative Murray, again.
Thank you.
Shortly.
Just one more thing I wanted to say. In this committee, and I've supported these votes, we've killed multiple bills that, you know, the quote unquote red flag law bills that, because we believe it's an infringement on constitutional rights for someone's Second Amendment rights to be taken away because someone fears they may do something. And that's what I'm seeing in this. We're saying the law enforcement officers fear that someone may dox them or someone may target them, and therefore they have a right to violate our constitutional rights. And I just think that's inconsistent. And I don't think that it just doesn't make any sense to me and doesn't align with what I know New Hampshire to be.
Thank you. Representative Murphy.
Thank you, Mr. Speaker. Mr. Chairman Roy.
Congratulations.
Well, look at that, elevated immediately.
You fired the other guy when he made all those mistakes.
I just wanted to chime in as the representative of a community that may be looking at an ICE facility siting in my town. I've talked to law enforcement. I've talked to the state police about this bill. Our community has a really good relationship with our police. We have phenomenal police officers. They're well respected. It's community policing, and the concern of the community, who all oppose the facility, not all, but a vast majority oppose, and they oppose it for different reasons, not political reasons, but costs and those kinds of things, and you know, tax increases and that things like that.
I was about to ask you if the community was going to make any money off of that at all.
No, we're going to lose $529,000 in property tax revenue if it's sold, and then of course the infrastructure impacts on police, fire, medical, etc. But the state, I talked to a state police officer, and he said he absolutely would never want to wear a mask. He said, I wear my uniform proudly. He said, I represent the state police. And he said, just like with body cams, he said, they're as protective as me as they are of the person that I'm dealing with. And I think there's a huge public trust issue, and failure to pass a bill like this, I'm very concerned, is going to only shoot that into the stars exponentially, because we have always, most of us live in communities where we respect our police officers. Police officers respect the people that they serve, and things go well. And when we put them in a position of having to, of masking or not being required to identify themselves. Number one, I'm not sure they want that. There may be a few that want that, but maybe those are the ones that need most to be identified. This is a bill that I really hoped that we could pass on a bipartisan way. It's scary to me to think of what's going to happen in my community with the number of ICE officers that will likely be there if this goes through, the number of new temporary residents we'll have in our community, and the division that will be created if our community loses faith and trust in our own law enforcement. So I don't know, just a different perspective, I guess.
Thank you, Representative Murphy. I just want to add what could currently, under the existing law, any community has the ability to control their police department, like the Portsmouth Police can say, our department will not wear masks. And so that is totally in the control of the local police departments. Still, and this law is not necessary for that. Any police department, any chief can say, we're not doing that in my community. We're not going to be part of this. But I would reiterate, there is a clear, tangible, I can give you lists of threats on ICE officers have gone up by 5,000% since the enforcement of immigration laws has started in full effect. If it's so scary to do this job, no one's going to want to do it. And these are laws that have to be enforced. But that's a federal thing, and I don't like us getting drawn into federal things. We have a nice, peaceful thing going here in this state, and I'd like to keep it that way. I would more support a law saying don't, except for emergencies, ask us for help, because it's just causing more division, and we like our police like us. But I'm never going to put them in a position where someone is going to take their picture and then go and do a facial scan on Google, figure out who they are because they're in the background of one of their kids' basketball games. And you know as well as I do, people are going to put that up. They're going to find their home address and they're going to say, this guy, and that is horrible. So until we can offer them full protection, I'm not going to ban them in circumstances where their police chief, who, hearing all the circumstances, decides this is a necessary thing for my guys and gals to do in this position. That should be allowed to those chiefs to determine for the safety of their officers and their families. And with that, I ask you to call the roll, please.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative Lascelles?
Yes.
Representative Devoyd?
Yes.
Representative Paquette?
Yes.
Representative Saborn Deschwanier?
Yes.
Representative Harriet Gathright?
No.
Representative Muse?
No.
Representative Newman?
No.
Representative Murphy?
No.
The clerk votes no. Representative Shear?
No.
Chairman Roy?
Chair votes yes.
7-6.
7-6, motion carries and expedient to legislate. With that, we're going to do one more, I think, unless anybody else wants to stay. But I think we've had enough for today, and we've got a lot left. Where is it? Where is it?
1173.
Maybe. Hold on a second. One thing at a time. I can't juggle.
1173 is a really simple one.
The definition. Okay. And this is you, motion? I open the hearing on House Bill 1158 and recognize Representative Rhodes to make a motion.
Thank you, Mr. Chairman. I move ITL for House Bill 1158.
Second.
Seconded by Representative Murray. Oh, okay, Representative Prue. Would you like to speak to your motion, Representative Rhodes?
Yes, thank you, Mr. Chairman. I do recognize the reason that the sponsor brought this bill forward. However, I would say that the the outcome that he's trying to achieve is not going to be achieved with changing the definition of what an intimate partner is. And we do not have time today, but I believe Friday we will exec another bill that will actually address the problem that he's trying to address, without having to change what an actual intimate partner actually is. And unfortunately, it would get more into the other bill, which I don't want to do. So that's all I can say right now.
Gotcha. Thank you. Representative Prue, would you like to speak to your second?
I'm all set, thanks.
I would just add that to me, it's very scary to just say that anyone that you've had intimate contact with would be eligible for a protective order at any time. We need to focus on victims and make sure that they have access to things, but we can't just throw it open and say anyone can get one of these orders. Our courts would be overwhelmed, and I'm not sure that it would be the best thing for victims themselves. With that, any further discussion? See, Representative Murray.
Yeah, I guess I would just uplift what Representative Rhodes said. That I do think there's a real problem that's being addressed by this, but I think that we will resolve it with another bill that has more carefully drafted language.
Thank you. Seeing nothing further, I'd ask the clerk to call the roll. The motion on the floor is an expedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative Lascelles,
Yes.
Representative Devoyd,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschenier,
Yes.
Representative Harriet Gathright,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
13-0.
Any deduction to consent? Seeing none, we'll go on consent. I hereby close the public hearing, executive session. I'm going to open the executive session on U1 1173, House Bill 1173, and I recognize you to make a motion. Second. Would you like to speak to your motion?
Very briefly, this is a bill that was passed unanimously by this committee and by the House on consent last year, and then got hijacked for some other purpose.
I second that as well. So let's do it again. Yes. Did we do it already?
I have a note that we exec this bill on January 29th. There was a 12-0 vote and we put it on consent. So.
Ditto.
Once again, everything I just did. was
Mr.
without-
Chair, in your defense, we really do have a list here
From the clerk.
that he is following. We are not pulling these out of a magic hat.
I think
No,
the
no.
clerk is going to blame it,
We have a lot
is
of
being
bills.
blamed for everything here.
Well, he did give me this yesterday morning, and it's a list of all the bills that say in committee, and once we exec them and give the report, they are no longer in committee. So there's a chance that we still had the reports, but I think I sent them all in, so
We were trying to.
this
pass
is
that
not
one,
updated.
Is that it?
Yeah.
We were going to pass it? Is that-
Yeah,
okay.
yeah, we unanimously already passed. it. Okay, with that, we're done for the day, and I will see you guys on Friday. We have a couple bills that are scheduled to start, and then we will hit back at the list of bills that we have left to exec. Yeah, maybe I'll have an updated list by then, so we'll see. In the meantime, see you tomorrow at session.